All right. Yep. Hi guys, it's Kathy. I hope you're doing well. I'm I'm not doing nothing until you guys tell me I'm live. Because I was just live for 8 minutes. I've been live now for 9 minutes and 11 seconds. Playing my video. What is going on with my camera? Oh, it looks terrible. It's all fuzzy. I look all white. In my screen, I'm correct. It's fine. It's just my camera. Who cares? Has nothing to do with the court videos. My camera has nothing to do. Okay, now I have to rewind it again and find where we were because I just started playing it. I know what's about to happen and you don't. Oh, that's so crazy. But the good news, guys, I might have been doing a live stream just for myself for a few minutes there, but I was not muted the entire time. The entire time my mute button was on point. My mute game was solid. No, that's weird. Hold on, let me look on this one. No, that's my camera's all messed up. I don't care though. I don't care. I don't care because that's fine. Well, you're here to see the court video, like this one right here. Now I have to rewind it a little. Oh no! Apparently, when you go back to the beginning to a different scene, it pops you the whole way back to the beginning of your video. That's fine. It's fine. All right. This is the end of him. So, as I was saying before,
And this whole story.
that you didn't hear, we went through. Oh my God, I was talking to each of you by name too. Hi, Mary. Oh man, no wonder you weren't answering me. That's terrible. Am I muted? Oh Jesus. Shut up, JK. You just scared me. All I saw was muted. We we've been through the closings, but now we have, the prosecutor can close one more time. Hi, Lizzie. They have one more bite of the apple, and then we get the verdict. Yeah, I yes I did. Yes I did. It was on you. That's not fair. That's worse than me starting a live 9 minutes and 11 seconds ago and no one watching. Is that JK just said it doesn't count. That's way worse because I was unmuted. Okay, press play, press play.
Relies on that
Please,
she would be
please
credible.
say you
So
can
I would
hear
ask
that.
you
We already heard
to
this
find
part.
Mr. Byer not guilty.
All right, that's where we stopped. We try to fix this camera. I should just leave it alone.
Rebuttal closed. Mr. Checo.
Katie's here. Hey, Katie, how are ya?
So I do want to admit a mistake in my previous slides and argument regarding the mental state for the attempted serious bodily injury assault. Forgive me. It's been a long week. Mr. Black is right on that point. You must find that he acted with intent and engaged in the substantial step with intent. That said, the same facts, the same actions demonstrate his intent. They demonstrate his purpose in squeezing her foot
Hi,
and
Terry Love.
twisting it to cause a refracture of that foot. That is his intent.
The first time around, it was right when he said that Tona said, "Are you guys still on the same case? Because I got to get out of here." It was right when he said that. And I cringed a little bit. But it's all right because she didn't hear.
And remember, she didn't just make this up after she got the protection order. She was frank about the tackling and about her foot from the very beginning. There's lots of discussion about social media posts and videos and concerts and burlesque dancing. None of that matters. None of that bears on her credibility. You heard from Dr. Mulchin, of course, she wasn't the ideal patient. She wasn't great about following up and wearing her boot. But that doesn't mean that what she told you on the witness stand is false. And the defense mischaracterized the instructions that she got from her doctor. And you heard about those instructions. Her last appointment in July of 2024, she was advised to wear a boot or a supportive shoe with orthotics. And she was doing pretty good and with her foot, and she felt comfortable with her foot. Now, was she following all the instructions? Probably not. But think about it. She's laying in her bed in the middle of the night sleeping. Is she supposed to be wearing a boot? No. This is where the argument starts. This is what leads into Mr. Byer then assaulting her. And when she's in that apartment, she is bearing weight on that foot. She's been dealing with this foot that's had injuries for years. She's accustomed to bearing weight on it. She's accustomed to dealing with the pain. And in this moment, she is running on adrenaline, and her focus is on getting them out of the apartment. So maybe it makes sense that she is bearing weight on this foot. She's used to the pain. She's used to the discomfort. That doesn't mean that she's making all this up. Now, you heard the officers, they didn't follow up on these injuries. And you saw that is a dimly lit apartment. She had just had the injury minutes, if not a couple hours before. And they weren't able to see anything right away. But as time goes on, witnesses are able to see a bruise. And frankly, those officers ignored what she was saying. They didn't ask her follow-up questions. They didn't ask about what actually happened. And that wasn't where her focus was. They should have asked those questions, and they didn't. Mr. Black was saying, well, she didn't get the arrest that she wanted. That's not true. You heard testimony that she didn't want to get him in trouble that night. She didn't want to get him arrested. She just wanted him out. She did not have a vendetta to get him arrested. And Mr. Black's also accusing the prosecution of trying to confuse you with this drawing that MJ made. And that is not true either. This is a useful drawing. It shows the diagram of where the rooms are, and it shows how close Mr. Byer was when Mary Jane claims she saw him in the bedroom, very close, right outside the door from where Constance was laying on her stomach on the floor. And even if you believe Miss Byer that he was on the bed in the bedroom, well, that makes sense, right? After she's screaming, after you hear bangs, you might believe that the children would come out of the room, might see him right by Miss Crowell. How easy, a few steps for him to be right back in the bedroom. Now, just a couple more points. And defense mentioned that Lily could be coached. That is pure speculation. There's no evidence that Miss Lily was coached and told what to testify to yesterday. And think about it. If she had been coached by her mom, wouldn't her story be much more elaborate? Wouldn't it be sophisticated? Wouldn't it go into detail of all the injuries and all the things that was going on? No, she testified to what a 9-year-old girl would have heard lying in her bed, what she would have saw when she got up. She wasn't elaborating on the bruise she saw. She said, "Yeah, I when it was light outside, I could see it." reject the argument that she was coached. And ultimately, what the defense is asking you to do is reject everything Ms. Crowell told you and that she made all this up. And think about her telling the officers initially what happened to her. As she told Dr. Trent that next morning. Then she told her doctor, Dr. Molchan, her foot doctor.
Like never, ever, ever, CJ, during those couple weeks you didn't wait there? You didn't just run to the bathroom real quick? Oops, I forgot my crutches. I've used this background before a couple times in my old software.
And what she told Detective Olazaba, and what most importantly, what she did for hours and hours yesterday, telling you she has not changed her story. Sure, she has elaborated and given more detail and given more context. Of course, that makes sense. Could be that she wasn't comfortable saying everything to police the first time. But that doesn't make her incredible, and that does not make her a person who got up on the stand and told you a false account. She's never changed her story about how she was assaulted by the defendant that night and how he attempted to cause a serious bodily injury to her foot. Believe Ms. Crowell and find Mr. Byer guilty.
That's as much as the trial as you're going to get.
All right. At
I
this
think that's
point,
it.
Caitlin, if you'd please stand up.
All right. All right, that's it. That's all we have here. Now. This is the clip I accidentally started playing 2 days ago. Yesterday? I have no idea. So, let me get the chat back. I have to be way more careful in my fast forward abilities today than I did before. Because I skipped over the whole. Alright.
The other, no reactions, nothing. This is a court of law. We will act appropriate at all times.
Yeah,
All right,
Josh.
let's go get the jury.
Act appropriate. Don't make Eric mad. I don't like him when he's mad. I think 82% of you or 86% of you yesterday said that he was guilty. Straighten up and fly right. Josh is never inappropriate. See? CJ said the same thing. Josh is always appropriate. He is. Now, it's what happens after the verdict and the jury leaves. I'm not sure. I didn't watch it. I just, I stumbled on it and then got out of it. I think something is going to change everybody's mind after the verdict is in. Everybody. I think. If I saw it right. I'm excited.
All right, everyone may be seated. All right. One second. All right, so juror number 12. I see you've got the manila envelope, so I presume then that you are the foreperson? All right. And the jury has reached verdicts. All right. If you would hand those in. Up to Andrew is fine. Thank you. All right, Mr. Byer, if you'd please stand for the reading of the verdicts. All right, people of the state of Colorado versus Kiefer Byer, 24 CR 6170. Jury verdict, attempted assault in the second degree. It is Roman numeral 1. We, the jury, find the defendant Kiefer Byer not guilty of attempted assault in the second degree, signature by the foreperson. Jury verdict, assault in the third degree. It is Roman numeral 1. We, the jury, find the defendant, Kiefer Byer, not guilty of assault in the third degree, signature by the foreperson. Sir, you may sit down. All right.
Excuse me, Judge. Don't tell him what to do. He's not a criminal. He's not a criminal. You can't tell him what to do anymore. He was just found not guilty by his peers. So you can't boss him around.
Would either side care for the polling of the jury? Prosecution?
No.
Defense?
No.
All right, ladies and gentlemen, you have completed your service as jurors with the thanks of the court. And I just have one last favor. The Chief Justice of the Colorado Supreme Court has asked trial judges such as myself to spend a couple minutes with y'all, with jurors, talking about jury service, everything from when you got your summons, the system, everything. See if there's anything we can improve, or what your experience was, so I can provide feedback to her. So for one last time, I'm going to ask if you'd go back into the jury deliberation room. I'll only be out here like 2 minutes, and then I'll be in. And at that time, like I told you during voir dire, any questions or anything else, and I can answer them for you. All right, all rise for the jury. Jury's released to the jury deliberation room.
Judge, if you give a suggestion card to the defendant, he's going to give it a 2 thumbs way up right now. But only for a moment. Here we go, guys.
All right, everyone may be seated. Judgments of the jury will be entered. 24 CR 6170 is dismissed. All bonds are released, and if there's no other holds, defendant will be released from custody.
Your Honor, based on the verdict, we would ask to readdress bond in 19 CR matter. We would ask
Hold on a second.
But
What's
wait,
the case number?
another case? What do you mean, Judge? Hi, Toast.
It's the revocation matter. One moment.
19 CR 436.
Yes.
And I believe the victim on that case, Catherine, has been watching on live stream. She may want to address the court. I can just have a couple minutes to see if she wants to be on WebEx.
But wait, a different victim is paying attention to this court case? A different victim, Catherine, is on the line? Another person he may or may not have assaulted? What?
WebEx on.
Is that what they
It is.
said?
Well, not. She could be on the live stream.
Okay, she is going to try to log on to WebEx.
Well, we're not going to be dealing with any of this today.
So if this is another victim, allegedly or not allegedly, hi Nan, do we think he's guilty now of the last one? Judge Eric? No. He doesn't give me a chat in his stream. I wish. Because he mutes himself sometimes and I want to say, you're muted, you're muted, you're muted. It's the right answer, machine. We all know
The
you.
only allegation is the
Welcome.
new charge. I don't know if there's anything to consider.
There's the other pending charge in county court, set for trial September 3rd, I believe.
And what is that? What is that one?
I think it's a domestic violence case. I think it's
Do you need the case number?
3rd-degree assault, false imprisonment, child abuse. 25M.
As a TV crime as well?
Yes, it's a different alleged victim.
I didn't see that one. It's 25M what?
1385,
For trial one?
September 3rd. Yes.
All right, well, I'm not going to rush into this. Bond's going to remain as set on the revocation. I will set it for Monday, and we can address bond fully on Monday. The victim can be prepared to log on and address the court at that time. And we'll see, we set a bond based on, well, the current status of things. All right, so I'll see everybody on Monday.
Can you hear me now? I think you can hear me now. Listen, I wasn't muted. For real, I wasn't muted. When I added that new window, it took the volume of my microphone and put it the whole way down to 0. But didn't mute me, so the red wasn't there. But you should be able to hear me now. I don't know why. I don't know why it's effing with me. It's like trying to really tick me off. I'm going to write a stern letter in a second. Okay. This is Judge Manning, okay? When I saw the heading, committee versus committee. Thank you. Oh, you're not Fozzie. You are not Fozzie. Are you Maria? You're not Maria. Wait, who are you? I have to get my chat box. It's hiding. Hold on. There we go. I don't know how to put it up on screen yet, but thank you so much, Kat. It is Maria. Is it Maria? Maria, last time you did that, you were Fozzie's pants for weeks. All right, Judge Manning. We're doing Judge Manning. We're trying very freaking desperately to do Judge Manning. When I first saw this heading, committee versus committee, right? I thought it was the last time I saw a heading like this, it was a court reporter. It was multiple court reporters. It was a disciplinary hearing for court reporters. They were getting in trouble because they have strict freaking deadlines and guidelines and rules that they have to live by. And they get paid like nothing. So there's court reporters you hire, the judges hire, and they work in the courts for like nothing, but they do get excellent benefits because they work for the government. And then there's court reporters that work for themselves, and they charge like, $40 an hour or something. So they don't get paid nothing. They get paid whatever they set their rate at, and whatever people will pay. And then you'll see when they go into a civil hearing, the judge will say to the plaintiff and the defendant or respond or whatever, do you want this recorded? If you want this recorded, you have to pay the court reporter today, $22 each. You have to pay it today. If you don't pay it, if you both don't pay it, she will not record, and you will have no transcript of this if you need it later. If only one of you want to do it, you got to pay the whole $44, and then you will have a transcript for later. And then they decide, well, I don't have any money today. Okay, then no court reporter. So when I saw this, I thought, oh my gosh, it's another court reporter disciplinary hearing, because those are always fun and stressful, and you feel so bad for the court reporters, but then sometimes you just don't feel bad for them. So I pressed play, and then I didn't even get to the hearing. I didn't even get to the committee versus committee, barely, just a little bit. I just had so much fun watching Judge Manning again that I thought, I have to do this. We're going to do this together, and if you're newer to court and you're not used to Judge Manning, she is GOAT. GOAT. She always will be. She is just so good. Here we go. We're going to get through half of it today, maybe half of it tomorrow.
Judge Manning doesn't have a problem getting a court reporter. All right. And those are the rules that court reporters have a job. And just like lawyers get paid, court reporters are going to get paid. So we're going to put it on the record. Both counsel, are you going to share intake now?
Yes, Your Honor. And for the record, I just wanted to note Zoe Grant, who's on here. She's actually an intern at my office. She's just observing.
Okay. Ms. Grant, since you're an intern, you don't have to keep your on if you don't want. I just like people to keep their, so that I can see them when they're, so you could, unless are you a law student?
She's interested in being a lawyer in the future. She's at UGA right now.
Oh, you couldn't get into a different school. Well, I think a lot of people that went, if they go to law school there, what they call double dogs or something like that. Good luck. And don't let anybody dissuade you and say, don't do it. do it. Lawyers serve a great purpose, no matter what, the public and stuff say. I had plenty of people say,
Trial.
don't do it. You're going to hate it. And you're going to not be a good lawyer. And they may have been right, but I think I didn't do too bad.
You're right.
Okay,
You
sir,
did
what about
great.
you? You going to share and take down?
Yes, Your Honor, but I just saw something flash across the screen about this being taped by a participant. And I
This is
wanted
taped
to-
by the court reporter only to use
Thank you.
as a, so that she can, I've been told I have an accent. I don't hear it. I don't hear it at all. But sometimes she has a hard time hearing. It's not an official copy. It is her copy so that when people want transcripts, she can actually watch it and see people's mouth move. So you can't get a copy from her. It's taken down and it's deleted. So her copy isn't available to anybody. It's just like one of the tape recorders that she'll have set up in the courtroom. And then once she does the transcription, she will actually delete it also. So she's recording it for her. No one else is. I'm not even recording it. I let her do it as a backup as opposed to a little micro cassette recorder. Miss Delabrato that's on here is the case manager. Her camera may come on or off, but that's it. Any exhibits, please mark them, email them, Ms. Sanders. I think everybody has her email. Don't talk over each other. This isn't for the lawyers as much as it's for the parties. If you interrupt or talk over each other, then she's going to throw her hands up, which is bad. But if she has to unmute, hell hath no fury, because then I'm angry because she's had to unmute and interrupt.
Look, I love Judge Manning, but what she said there just put fear right into me. Just put fear right into me.
Interrupt people. Lawyers get excited and talk over one another, and I interrupt them until I'm not to. Listen to the question. For instance, Beth, say it one more time, sir.
It's Spatalnik, but you can just call me John.
Okay, Spatalnik. I'll try to remember. It'll probably change if he objects to a question. Whoever is answering the question, just stop. Let him state his objection. Wait on Ms. Wise to respond, then wait on me to do it. Okay, so everybody has to listen. If an attorney objects, then they have to object. I have to listen to the response. All right. So, and we're not going to be disrespectful. Everybody's going to talk to me. And if you say, I want to say something else and you raise your hand, I'm probably going to tell you, you may want to talk to your lawyer before you make some statement that they're not prepared for. Because all lawyers on here have been in that situation where we're going, oh my God. So I'm not going to kind of let you do that, just out of respect for the other people in here that are in six-figure debt or were at some point in six-figure debt. Don't worry about that, Miss Grant. Your parents are going to pay for everything. You're not going to have six-figure debt. All right. Are there going to be some openings?
Just brief one, Your Honor.
All right. Go ahead, sir.
Thank you, Your Honor. I did go to University of Georgia Law School, but I'm not a double dog. I'm a Buckeye. Okay. So, but I want to say this, that, there's a phrase that sums up for us while we're here today, and that's recepts loquitur. The thing speaks for itself. What I believe that the evidence is going to show is that the respondent, who I may mistakenly refer to as defendant throughout this, if I do, I'm sorry. He's respondent. He's not the defendant.
I would never make
but
that
he
mistake.
Has,
Never.
we allege, and we'll show the court 42 text messages that are violations of the protective order that was entered to the court by the court first on December 23rd of 21, and then modified that same day from 12 months to 6 months, and then modified again January 21st of
Yes, she did. She just streamed a couple days ago, CJ. I saw that. I didn't watch it yet.
2022.
Judge Manning, not Mrs. Fields.
After
she did too.
the third
Mrs. Fields
hearing
did
on
too.
the matter. You'll also see where he delivered 2 gifts to the petitioner. He sent her a letter. He sent her 2 videos. He emailed her twice. He posted about her on Facebook 4 times, and he set up a website wherein he has written about her and included her pictures and photos on that website. So
Guys, he had a protection order, so he made his own website of her with her pictures. And don't worry, his lawyer has an excuse for that.
we're complaining that these are violations of the protective order. Notwithstanding that, I mean, what we see as abusive, name-calling, argumentative, wrought with accusation and threats and outrageous claims, I believe that opposing counsel is going to argue or present to the court that, well, the correspondence that's complained of is really related to him wanting to speak to his daughter. And I believe that's outrageous because nobody has stood in the way of him having correspondence by phone with his daughter. And the bulk of everything that we're going to complain of and show the court as being violative of the protective order has nothing at all to do with that. So we're prepared to go. I know there's a lot of exhibits, and I've prepared, along with the exhibits, which I've sent to the court, a detailed exhibit list where it refers specifically to the paragraph of the motion to extend and for contempt. It shows the exhibit number, it shows the date and the time and what the thing was, what the alleged violation was.
I
In
hope
the end,
it's text messages.
what we are asking the court to do is to hold the respondent accountable for what he appears to believe is a court suggestion rather than a court order. And we're asking the court to extend the protective order for either 12 months or 3 years, preferably 3 years. And we're asking for attorney's fees for having to have brought this. And I'll shut up now. I'm prepared to begin, but I believe counsel desires to have the floor.
When did you email your evidence one, and did you share it with Ms. Wise?
It was all shared with Ms. Wise, and it was emailed. It was uploaded or provided to Ms. Delabrado and or Ms. Bowles. Let me pull that up and find it while Ms. Wise is
It was the day before the original hearing, so I guess that would have been Monday.
Okay, all right, I'm just checking. Do you remember like who the email was from?
There would be one from Mr. Spitalnik and one from myself, and it was to the case management email that's on the original Rule NISI.
Okay, all right. All right, good. I may have to you're both going to share your screens though, am I correct?
Yes, Your Honor.
Okay, all right. So, I mean, I don't look at evidence and stuff like that beforehand. Like I said, don't forget, we're going to have to email it to Madam Court Reporter later. All right, go ahead, Ms. Wise.
Yes, Your Honor. So for the record, Kimmy Wise for the respondent, Jason Committee. So I just entered the case a few days ago. Cindy Patton at our office represented the respondent in the divorce case, but she just finished out her notice with our firm. So I also just took over that case as well. So any grace is appreciated, but I believe I'm up to date. So I'm going to give a brief summary on why this should not be extended, the contempt should not be granted, and the evidence is going to support that. So first, the original 6-month TPO was granted because Samantha alleged that Jason was manic and on drugs, and that the restrictions regarding visitation, those were ordered when both parties provided the court with positive drug tests. So the vast majority of the communications that the other side is bringing today occurred before Jason entered rehab, which happened on February 23rd, 2022. So the vast majority of them, quite frankly, Jason clearly didn't have the willful intent to violate the order and didn't know what he was doing. And it's pretty evident by the communications. You're going to see that. Most of them are ramblings. And yes, some of it's talking about him wanting to see and talk to his daughter, but he was on drugs. His record reflects that, and he went to rehab. So most of it happened before then. Since then, he's completed a 45-day inpatient rehab program, a 60-day intensive outpatient program, NA meetings, 300 hours of therapy, continuing to work the program. He goes to weekly outpatient meetings. He continues to go to therapy. He is also part of Phoenix twice a week, which it's like a sport organization for sober people. And he's been clean and sober ever since. And we have plenty of drug tests demonstrating that as well. In the other thing is most of these.
I don't know if I trust sober people in sports, though.
All of these communications also occurred from Colorado. So Jason has also lived in Colorado since February 22nd, 2022, the day before he went into rehab. So he's over 1,900 miles away from Samantha, and she's, of course, well aware of this. Further, the vast majority of these communications are from months ago. So claims based on them should be barred pursuant to, I don't know if it's laches or laches, but it's under OCGA 9-3-3, as Samantha delayed in asserting her claim, and the delay wasn't excusable, and obviously it has caused undue prejudice to Jason. For the same reasons, they should be barred pursuant to waiver under OCGA 9-11.
That makes no sense to me. January, the judge says you may not contact her. He contacts her in March. These are just made up months, though. I mean, there are real months. There really is a January and a March, but they're made up. And in December, she says, look, this is what he did. Now, she's not allowed to do that because she waited too long. He still did it. She still has the text. I don't know.
-8, as again, Samantha unreasonably delayed seeking relief of contempt. I mean, supposedly many of these communications are happening back in December, back in January, but even when we came back before the court in late January, these issues aren't brought up. We didn't have a motion for contempt then. So she has waived any right to complain about these today. Samantha filed her motion for contempt and to extend the TPO on June 22nd after 7 p.m. That's the day the TPO was set to expire. And quite frankly, Jason wasn't represented in the TPO at that time. I joined the case on Monday. I don't think he quite understood that the TPO had not expired pending this hearing, but nonetheless, of additional importance, Samantha repeatedly contacted Jason directly and indirectly, sent him mixed signals, said his communications were okay, approved him stopping by the house to drop off items, wrote him a letter, appeared to try and reconcile with him. I mean, some of these mixed signals were as recent as May, June, even 2 days ago, where she's telling the mom to tell him to.
Doesn't matter. Doesn't matter. She can dance in front of him naked. It doesn't matter.
Just sign the deal, and that she wants all this over
Objection.
with. So,
objection. I don't think she can use hearsay in her statement. And she's absolutely saying purportedly what was said between Samantha Committee and Jason Committee's mother. And that's improper. And I'd ask that that be stricken.
Your Honor, my response would be that this is opening statements and we're not bound to those same rules. I'm talking about what the evidence will show. When I get to that point in my actual evidentiary part of my case, he can make the objection and then the court can rule.
So, but is Mr. Committee's mom going to be here?
She is not, but there are text messages that I will introduce to the court. And the important part is what Samantha said, and obviously statements by a party opponent are not hearsay.
Okay, yeah, just skip over what mother-in-law / mom said and, get to your evidence then. Go ahead.
Yes, Your Honor. So there are, of course, times where Jason was distraught about not getting to speak with his daughter. Samantha did basically cut off contact with Mia. He was supposed to get 3 hours 2 times a week. And since he's in Colorado, these would be, I guess, supervised phone calls instead. But actually, she was only allowing him to talk to her approximately once every 2 weeks. Now, recently, I did confirm with opposing counsel that he is okay with Jason calling every day during reasonable hours. And so now my understanding is Jason has done that. But in the past, he wasn't getting to talk to her, the daughter, for weeks and months. And yes, he did get upset, and he will admit to that. I have only seen one message from Samantha to Jason where she finally told Jason that him texting, where he was asking about phone visits with their daughter Mia, was a violation of the court order, which it isn't, pursuant to paragraph 27 of the order. But it's important to note that that's the one time I've seen where she actually said, hey, you can't talk to me, you can't communicate with me. So again, this waiver issue, especially when coupled with the fact that Samantha was reaching out to him and sending him love letters and lyrics to songs about reconciling. Some of the evidence allegedly shows Jason supposedly violating this order are things like Facebook posts and his website for an organization for domestic violence survivors. These aren't communications towards Samantha. They're Jason's personal writings protected under free speech. We're not even sure how Samantha found out about them because she's blocked on his Facebook. The website is in Colorado. I couldn't even find it with a Google search until opposing counsel actually gave me the specific link. So unless she's stalking him, I'm not sure how she even found out. But further,
Excuse me, what does it matter? He has her pictures up on his website. He posted about her. He made a website about her with her pictures on it. What does it matter how she found out? That does not matter.
For any allegation that these internet postings were harassment really can't be entertained. And you'll see that when you see the postings, but also Samantha herself has posted many private things about herself all over the internet. And so I don't really understand how there can be an argument that him posting his feelings is harassment. Any extension of a TPO is obviously based on the same factor of a TPO. Here, we don't have new acts of family violence. We don't have likelihood that family violence will occur since he's 1,900 miles away. And we certainly don't have that by a preponderance of the evidence. Finally, the parties are in an active divorce case in Fulton. They just had a 60-day status conference yesterday. They've consented to a guardian, Tori White. The judge is signing that order. So obviously any protections and, dealing with not talking to Samantha, that can all happen through the divorce case. He doesn't want to talk to Samantha. He just wants to talk to his daughter. So I don't think these problems are going to continue. I have now very clearly explained to Jason what he needs to do, and he has assured me that will happen. So based on all the above and what the evidence is going to show, I don't think it's appropriate today for the court to grant the contempt or extend the TPO.
Okay. The judge gave an order. He broke it 60 times. End of story.
All right. Go ahead and call your first witness, counsel.
Thank you, Your Honor. I call Jason Committee to the stand.
All right. If both of you will raise your right hand for me, Mr. and Miss Committee, and take yourselves off mute.
Judge, those
All right.
instructions
Do y'all
are
swear for
backwards.
testimony you're about to give is the truth, whole truth, nothing but the truth? Mr. Committee?
I do.
Miss Committee?
I do.
All right. You can both put your hands down. Go ahead, counsel.
Your Honor, my internet connection is unstable for some reason right now, so I'm going to do my best. If I'm glitching out or anything, just give me a little leeway here, okay?
I will just keep your eyes on Madam Court Reporter because she's going to wave her hands. So just, I don't know if there's somewhere where you can get where it's more stable.
I have Comcast, Your Honor. That's the best I can do.
See, I can't make any comments about Comcast. Just get as close to the router or plug in directly or something as opposed to wireless, whatever you can do to try to make it stable. But keep your eye on Madam Court Reporter or anyone else, and then we'll let you know if we can't hear you.
Okay.
All right, go ahead, counsel.
Thank you, Your Honor. Mr. Committee, you were represented by Bernard Papacayu. during the second
That
hearing
sounds delicious.
on the protective order, weren't you?
Correct. That was after the Judge Houston had already made her decision to issue the court.
Okay, I'm asking you, the second hearing on the 23rd of December, if you were represented by Bernard Pepecue.
Can you repeat that? I was missing what you just said.
You were represented at the second hearing on December 23rd.
Correct. I believe you were trying to
No.
violate the order.
Look, so, Mr. Committee. So when he asks you a question, he wants a yes or a no. Okay, so if he needs something after that, he will follow up. Listen
Your Honor.
closely to the questions. That's okay.
And
yes.
you were aware then on the 23rd of December, 2021, that a 12-month order was initially entered and then modified that same day to be a 6-month order, weren't you?
Yes.
Okay, and you read that order, didn't you?
Yes.
And you understood that you were not to have contact except as that order provided, right?
Yes, I believe so.
Okay, I'm going to, Your Honor, do I need to enter the 3 orders, or is that, I have them as exhibits 1, 2, and 3, and I'm sharing the
None of us are lawyers except Peg Leg, but he's not here. And all of us know, you just ask her to take judicial notice of them. You don't have to enter them as an exhibit, sir, but you're going to, and that's fine because you've already printed them out for her. But no, sir, it says no. I don't understand lawyers lately, guys. We know that she's not allowed to say, yeah, well, the victim called him. We know she's not allowed to use that as an excuse. We know all he has to do is ask her to take judicial notice of the record. Why? Why are they acting like this in all of these cases?
screen now. This is petitioner's exhibit 2, which is the amended order, the 6-month order. Can you see that all right?
I can.
This was from 2021.
Mr. Committee, this is the order that you are familiar with, correct? Is Mr. Committee with us still? I don't see him on the screen.
Jason, can you hear us?
Yes, I can hear you.
So you have
Okay.
to answer when he asks you a question, okay? He asked you a question about the thing showing on the screen.
I can see the thing on the screen.
So answer his question.
I didn't hear the question, Your Honor. My internet was choppy, I guess. What did you ask?
You're familiar with petitioner's exhibit number 2, right?
Yes.
And you understood that you were prohibited specifically from having any correspondence, direct or indirect, with the petitioner. Is that correct?
I believe in the first 2 weeks of the order, I wasn't completely clear as to what those were. Those were clarified for me at the January 21st hearing by Judge Houston.
Okay, and those were clarified for you based on what I'm going to show here now as petitioner's exhibit number 4. Is that correct? This was shown at the hearing on January 21st? And the court explained to you that you could not.
Well, don't tell me what the court explained. Ask him a
Thank you.
question because nobody knows what Judge Houston explained except Judge Houston.
Okay.
Sir, I'm trying
Isn't
to read
it
that.
true that you understood that your Facebook posting as a result of that hearing on the 21st was inappropriate and you were prohibited from doing that?
Your Honor, I'm going to object to the compound question.
What is this? Would be a good first question for him.
Mr. Committee, is this a posting from December 23rd at 3:58 PM that you posted on Facebook?
It is.
Okay. And therein you mentioned your wife, Samantha. Is that correct?
That is correct.
Okay. And it was at hearing, was it complained of by petitioner?
I'm not sure. I believe so, yes.
Well, at hearing, were you admonished for having posted that?
I'm not sure what you mean by admonished.
Were you told that you can't do that?
I don't recall. I was on drugs at the time.
I'm sorry, say that again?
I was on.
You were on drugs at the time? He's frozen. I can't.
We're gonna have to fix this. This is gonna be a long hearing, and Miss Sanders has a hard stop at 1:58 PM.
We gotta have to fix this. Is
I
scary.
will call him and see if he can switch.
I mean, maybe he needs to mute his computer so we can see him, call in on his phone so we have better audio. But
Yeah, can I go ahead and can you give me 2 minutes so I can switch to my phone to do this hearing?
okay, it's gonna be hard for you to see the exhibit, so I would keep your computer up, mute
Okay.
it all the way, and your phone will be audio. Miss Sanders, that shouldn't give feedback, right? Okay, but you gotta mute your computer, but you're gonna have to use phone for audio.
Okay, give me 2 minutes.
While he's doing that, Your Honor, will the court admit exhibits 1, 2, and 3 as the 3 orders regarding the protective order in succession?
No objection, Your Honor. They're already part of the record.
So assault 2, the amended order, 4 is a Facebook.
So it just, I just semi a little bit crashed, but at least this is still going. So you can see it. There, okay. I think I'm gonna wait until I catch up to my live stream before I press play. It was the chat box. The chat box, I don't know what happened. It just killed my screen. There we go. Right. Yeah, I'm good. I'm gonna press play.
Post, what is 1 and 3?
1, Your Honor, I'm sharing that on the screen now, was how it was initially entered as a 12-month protective order,
Okay.
and then modified that same day. And then 3 is the order as it was amended. That's on the screen now.
That's not working. I don't think that's working. Because it's not. I don't know what's going on. I do not know. We were going fine, and then I just crashed. Is it over? Or am I still streaming? Can anybody still hear me? I actually think you can hear me. I didn't. Alright. I'm just gonna add it again. I don't know why it did that. There. That looks much better.
So the 3 court orders, P1, 2, and 3 are admitted, and all right, and the 4.
Oh my gosh, you're right. There's no. Oh, I'm so mad. I'm getting so mad. I don't really get mad, but this is killing me. If this doesn't get better this week, guys, I'm throwing it away. This is supposed to be really good shit. All right. We're at 26:38. I'll bump it back to 26.
Mr. Committee, do you have the phone numbers that you could call into?
I'm connecting with my phone right now, Your Honor.
So there are phone numbers that you could call into for audio. Do you have those?
I'm just connecting through the Zoom on my phone. It has a stable connection. I have
Okay.
to be able to hear you guys too, but my problem on this side is that I can't hear you
I
guys.
was, okay, so. There's phone numbers on there. Are they not on there for you to call into? If you have to connect the normal Zoom link, that's fine. I was asking if there were phone numbers on there. Ms.
I believe
Delabrato,
there are.
from now on, that's why we need the entire Zoom link, including the phone numbers if somebody has to call in via phone, okay? All right,
Okay.
mute your
Phone
computer.
number in the chat box.
All right, you have to mute your computer, sir.
I see his phone on there and it looks like he just muted his computer, but he's connecting the audio on his phone. So Jason, you can turn your video off your phone and just.
I don't know why you can't hear it. I hear it so loud it's echoing here. How can you not hear the video? All right, let me try something else.
Use the audio.
How's that? Can you hear the video now?
Now, okay, unmute the audio, Mr. Committee, on your phone.
Okay, do you have me now?
Okay, now you're gonna freeze on the video, so
You can hear.
You want him to turn his video on his phone as well?
God.
I mean, Mr. Committee, if you have, are we frozen on your end on the video on the computer?
Hold on one second.
I mean, you're looking at it, the computer. Are we frozen?
Now you get to hear their tech issues.
It goes in and out. So I'm going to use my phone by itself.
All right, then turn the audio video on, turn your computer off because you're going to get a lot of feedback.
Okay, there we go.
You're not, your video's not on your phone.
Okay. Perfect. Okay, do you have me?
Yeah, I'm removing your computer because we're going to get feedback.
All right.
All right, go ahead, sir, counsel. That's the other. He's showing the exhibit 4.
Okay, this is, you admit that this is a Facebook posting that you posted, isn't that right, Mr. Committee?
Yes, it is.
And in there, you specifically complaining about what happened in court. Is that right?
Yes, very much so.
Okay. I'm going to tender this as exhibit number 4, Your Honor.
No objection, Your Honor.
It's admitted.
Okay. I'm going to go to the next exhibit now. The following day, you posted another Facebook posting, didn't you? Is this a posting that you posted on December 24th on Facebook?
Yes, it is.
Okay. And there's nothing in here about you speaking to your daughter, is there?
No, but I wasn't speaking to my wife either. I was speaking to my friends and family.
Okay.
She's blocked from seeing my Facebook. She's been blocked from my Facebook for many years.
So you're writing about Samantha to the rest of the world.
I'm
on
writing about
Facebook,
my
right?
personal experience, Mr. Spatanik.
Mr. Committee, yes or no? Then you can give him an explanation. Please.
No, Your Honor. I'm not writing about my wife. I'm writing. Carry on.
Okay,
Your Honor,
well,
I'm just going to, Mr. Spittelnik, I'm going to read back what you have because I did not hear a complete question. I have question, okay, and there's nothing in here about you speaking to your daughter. Is there answer? No, but I wasn't speaking to my wife either. I was speaking to my friends and family. Question, okay. Answer,
I'm sorry.
It's okay. Your question was, so you're writing about Samantha to the rest of the world? And then he interrupted.
That's the question. I'd go ahead and tender this as petitioner's exhibit number 5, Your Honor.
No objection, Your Honor.
Okay, I'm not sure if it's storming really bad where anyone else is, so if it is, and your power goes off, just keep trying to come back on.
Nope, no power issues. I forbid it. I just want this to keep going, Judge. Judge. She unmuted. Go get him. Get him. Hell has no fury. Kelly, that is awesome. What game does he play? Do you know what game he plays? I need to know because my son.
As a co-host also, okay? I can't control the weather, and I have tried, but the JNC didn't send me to get an interview with Kemp, so he's not gonna let me control the weather.
May I continue?
Okay, go ahead.
I'm sorry. Okay. I'm gonna tender or I'm going to show you what's been marked petitioner's exhibit number 6. Is this a gift that you sent to your wife on Christmas Day in 2021?
That is a gift that I gave to my daughter to give to my wife as a present from her.
Okay, thank you. I'll tender that, Your Honor, as exhibit number 6.
Your Honor, that picture has been modified.
Not a question.
Okay.
Anything on 6?
No, Your Honor.
All right, it's admitted.
Thank you, Your Honor.
Okay.
I'm going to show you now petitioner's exhibit number 7, which purports to be text messages sent by you to Miss Committee. Can you confirm that that's what this is?
Can you scroll down?
Sure.
Yes, I did send that to Miss Committee.
Okay. And that was sent to Miss Committee by you on the 25th, Christmas Day, 2021, correct?
Correct. My daughter
Okay.
had broken her tablet and I bought her a new one.
Mr. Committee.
Sorry, Your Honor, yes or no? I apologize.
You know, these lawyers have been practicing law forever, and I've even played basketball longer than LeBron James. So we know what we're doing. And if LeBron comes down here, I'll take him up in one-on-one. Okay. Let them do their job.
Yes, Your Honor.
I didn't know you were a hoopster. Okay. We learn something new every day. There is the things that you are texting her about on this text message. Those were specifically prohibited by the second amended Family Violence Protective Order, weren't they?
I've discussed, I have no idea. I don't know how to answer that.
Mr. Committee, you stated a moment ago that after the hearing on December 23rd, I'm sorry, January 23rd, that the court addressed these and that you knew at that time that you could not do this, right? But it was in plain language in the first amended protective order that the only thing that you could text about was logistics associated with visitation. You knew that, didn't you?
Your Honor, I'm going to object again to the compound question.
Your Honor, I don't think it's a compound question. To say you knew that added on to the question does not make it 2 questions.
So just try to make it a clearer question.
Okay.
For
Thank you, Your
him,
Honor.
because and Mr. Committee, let's not make this harder than it is.
Okay.
He's asking you simple questions. He's asking you what time it is and not how to build the watch. Okay? Listen to his questions. Try again.
When you sent the text message, you knew that that was prohibited, didn't you?
I did not understand at this time text message was prohibited. No.
You stated earlier that you read the order, right?
I did read the order.
And in the order, at paragraph number 27, let's pull the order up. This is the order that was first amended December 23rd, and you had a copy of it, and you stated that you read it. Can you see it?
I can see it.
Okay, let's come down here. Number 27, can you see that?
I can see that.
Read what it says.
Communication between the parties should solely be via text message or the use of My Family Wizard. Further, any such communications should be regarding logistics of parenting time and shall not be a violation of the order, as long as communications comply with the foregoing parameters.
Okay, now you understood from reading that just now that you could not write to her about things that were unrelated to the visitation logistics. True?
I understand reading that just now, but I did not understand that the text message that I made was a violation at that time.
Okay, let's look at
Listen, guys, this is just advice. Never marry to a name that frustrates you. Committee is frustrating. Don't marry Mr. Tax Return. Don't marry Mr. Wash the Dishes. Don't marry people with names like that. Committees are, just like JK said, frustrating and hard to get anything out of.
have I tendered, Your Honor,
Not
Exhibit 7?
Not yet.
Okay. This has to do with topics other than visitation, and you admit that, right?
Sure, yes.
Okay.
I am going to go out on a limb and say this is not a violation of the protection order. Him saying I got her new tablet, I don't know. This one is hard for me to say. Yeah, he violated the protection order. The gift, definitely, absolutely.
Exhibit number 7, which has, let's see, 1, 2, 3, 4, 5, 6, 7, 8 purported violations of the order on it, Your Honor.
All right, Ms. Wise.
That one's a violation.
So my only objection, Your Honor, which really stands for all of these, is obviously we shouldn't be getting into the text message before they're tendered, but also that, again, I don't believe any of these are relevant because we've already had hearings after this date where they weren't brought up, and I believe they were waived.
Your Honor, first of all, when she says they weren't brought up, they were discussed specifically at the prior hearing. He was represented by counsel. We don't want to go into what the court said because Judge Houston Habrowski's not here to testify, but we can ask her to come in and testify. I'm not sure whether the court has her notes regarding that issue, but Ms. Delabrado was there at the hearing and we can have her testify.
We're not going to have anybody testify. What Judge Houston says is what's in Judge Houston's order.
Thank you.
Again, I tendered Exhibit 7. It stands for what it stands for, and Judge Manning, you will either agree with counsel that it's in some way waived or it's not.
All right, and I'm assuming this part before the other amended order in January 24th. That's what you mean.
That is correct.
Right. I'll admit it, and I'll just give it the weight, be it very little or what, so that it is.
Kit Kat's right. Clear violation.
Okay, and I would ask that the court note that the top part, the first part.
I think there's another one right after the tablet, but before the I love you, there was a paragraph that we couldn't see, but I saw parts of it, and I think that one was a violation. I don't think that one was parenting. It's something about this situation sucks or something.
where I do not have a red box around says I'm outside, we're not alleging that that is a violation because that was allowed by the order.
That one was scary.
Okay. And I want everybody to know, I have two screens. So if I'm looking this way, I'm looking at the exhibits. Please don't think I'm watching the news or anything like that. I have, Ms. Sanders knows I have multiple screens. So I'm looking at my other screen so that I can see the exhibits.
Well, we understood that you had a basketball game on there, so maybe you're watching
LeBron James hasn't called me yet, but I'm ready. Whenever
HBO series or something.
All
Okay.
right, go ahead.
Okay, I'm going to show what was now counsel raised an issue, and I'm not sure from a housekeeping standpoint how the court would have me do this. How can I not show an exhibit to the court when I'm asking him to identify it when we're doing a share screen? I could, if we were in the courtroom, hand it to him, let him look at it and identify it. But the only way to have him identify it now is by sharing the screen. I could ask your court to close their eyes.
I do that a lot.
I'm not asking that he not show it. I'm saying we can't get into the substance of the exhibit before it has been authenticated and admitted.
Well, I disagree.
Hold on. If you're going to show something, I'll look here, and then once it's admitted, I'll be glad to read it on my screen. How about that?
I believe I can ask questions about an exhibit before I tender it.
Show it to him, have him look at it, identify it.
No, you can't.
And then you can ask questions, and I can look at it whenever it's appropriate for me to look at it.
Okay. I am about to put on the screen an exhibit that Your Honor has never seen, and she should look the other way. This is petitioner's exhibit number 8. Mr. Committee, is this a Facebook posting that you posted at 2:54 a.m. on December 27, 2021?
Yes, it is.
Okay. And down towards the bottom, I have a red box around a portion that I felt was something that I wanted the court to see. If Miss Wise prefers me to get rid of the box and then the court can read the whole thing, I'm willing to do that.
So it's not about the box. It's just about the rules of evidence and about the fact that now you need to tender the exhibit.
I'm about to, but thank you. 31 years wasn't enough for me to do this, and I don't need to be a smarty pants. Your Honor, I tender exhibit.
Sir, you just showed a message and got into the text messages before you tendered it. You just did that, sir. We watched you. Dumbass.
Number 8.
And Your Honor, I'm just going to say same objection in terms of the waiver, but I understand your ruling.
All right, yeah, I'll let it in and give it the what little weight it needs to be given. And there you go. So that's where I came up with the whole LeBron James thing. Let me explain this. So I was up in Cobb County one time, and I had and now that I'm in my late 20s, hold your laughter, Miss Sanders. I understand when you're little, but I had an older gentleman who was making an argument and went on about him practicing law, 387 years and looked at me, this young, wet behind the ears, blah, blah, blah. And he'd practiced law longer than me and blah, blah, blah. So and Judge Poole, I think, has his transcript. And I said, Judge Poole, before I respond to anything, can I respond to that? I have played basketball longer than LeBron James, but it doesn't mean I'm better than him. So that's what I would say. So I have seen some fresh out of ink, barely dry on their bar card lawyers that would scare the tar out of me if I was on the other side. So I respected everybody in here's practice. Everybody went to law school. Everybody took the same bar. People may have even sat for the third day that they could practice in like Cherokee County, as I used to joke with clients about. But I appreciate that. But we're all very competent people here, myself included, I hope. So go ahead. We'll give that, but no more. She's just trying to get the rules of evidence, and I completely understand. Let's give everybody a little bit of respect here. Go ahead, sir.
I'm going to show you now, Mr. Committee, exhibit number 9, and ask if you can identify this as a gift that you delivered or caused to be delivered to Miss Committee.
That is a piece of Art that I made with my daughter, and my daughter took it home. I don't know what she did with it.
Okay, Mr. Committee, you delivered this to Miss Committee, didn't you?
I did not. I gave that to my daughter during our visitation, and she took it home with her. That's all I know.
Not a
Was
violation.
it for Miss Committee?
I made it with my daughter at the community center, and my daughter wanted to take it with her. My daughter
Hey,
also
stop. Before he asked you about a bracelet, was this a gift given to your daughter to give to Miss Committee is the question.
It was a piece of art my daughter took home.
Was this gift?
I did not tell my daughter to go give it to her mother.
Then that would be a no. Thank you.
Not a violation.
Mr. Committee, when you look at this, it says love, right, and heals, and 2022 through 2012. What year was it that you married, Miss Committee?
Your
I'm
Honor,
not saying
again, I
that-
just want to, for the record, I just want to object to this being gone into without it being tendered and admitted.
Dumb ass.
Your Honor,
She's
I
right.
respectfully appreciate that, and I'm going to tender Exhibit 9 as evidence.
And just same objection for the record.
So when was this made? I mean, because I'm really curious about anything that's happened after December.
It was on January 14th when I had my one visitation with my daughter.
No, look, sir, one more time. What time is it? Don't tell me how to build the clock. Tell me it's 10:26. When was this gift or this thing made? January what of what year?
January 14th, 2022.
Boom. I'll admit it and give it whatever little weight it needs to be.
Thank you, Your Honor.
It wasn't a violation until he put his wedding
I'm
dates
pulling
on
up
there.
Exhibit 10. Mr. Committee, did you delivered this to her residence, didn't you?
What is
It's a
it?
handwritten. Is this a letter written by you, Mr. Committee?
It is. It was attached to the child support that is, you can see behind it.
Mr. Committee, I'm going to ask again. Is this a handwritten letter from you?
Yes, it is.
Okay. Isn't it true that you delivered this directly to the residence of petitioner?
To the mailbox
yes or
with the
no?
child support in it. Yes.
Thank you. I tender Exhibit 10, Your Honor, for whatever value you give it.
I just want to clarify the date.
He took it away. Okay. I'm just going to bump it back a second or 3. My attorney told me not to give you any money because I wasn't arreared or arrested or I wasn't something to by the judge. Ordered. I wasn't ordered to by the judge. How even I am beginning to think. However, I am beginning to think that these attorneys are getting paid. We got through it.
10, Your Honor, for whatever value you give it.
I just want to clarify the date that it was delivered.
Isn't it true, sir, that Mr. Committee, that it was delivered on January 2nd, 2022?
I'm not sure of the date. I can't.
Okay. Before we tender it, then I have a video captured from a Ring camera that I'm going to show you now. Your Honor, I'm not sure how to show the video without you seeing it. Have him identify it. And
I can minimize my exhibit screen.
okay. Are you minimized?
I am. And Mr. Committee, if he says it was January the 2nd, and you don't remember that the letter was allegedly January the 2nd, you could say, I know it was January 2022, if you don't remember the exact date. But
Okay,
he's going to show the video.
I know it was January 2022. I delivered it with
Okay.
child support.
That's good enough for me, Ms. Wise.
Yes, Your
Okay.
Honor.
It's
Okay.
admitted.
Okay, so I'm tendering the video as well, Your Honor. And
All
the
right,
reason,
You could show the video and I'll keep my exhibit
Okay.
screen up.
thank you, Your Honor. I'm trying to share the video, but it's coming up on the wrong screen.
So you have to so what you have to do is
Yes.
take down what you're showing and probably
Right.
reshare the video.
Video cover. Let's see.
Your Honor, I
Believe it or not,
admitted to-
Mr. Committee, believe it or not, this is much better than all of us sitting in a courtroom and possibly getting exposed to COVID. It's my opinion.
Yeah.
I'm trying to share and okay, here we go. Share screen 1. Let's see if
It's no use screaming at him to help him because he can't hear
let's
you.
see. I
Just
think I've
watch.
got this now. Can the court
I
Kim,
can't. I'll have to rely on Ms. Wise if she could see it because I'm
Ms.
minimized.
Wise, can you see it?
Not yet. I see your list of exhibits.
Okay, I'm sorry.
You
Let's
may
try
have to
this one.
stop
let's-
screen. Yeah,
yeah.
there, I see it.
Okay.
There you go.
Violation.
Mr. Committee,
Violation of
can you
protection
see
order.
that? Is that you delivering that handwritten email or letter?
Yes, with the child support, I'm delivering
Okay,
the
you
child
can-
support. in the letter.
I didn't ask you about the child support, did I?
No, you didn't, but that's
Okay.
not fair to say that I delivered that without the child support along with it.
Your Honor, would it be okay if I instructed him?
Yes, and I can. I tell you what, Mr. Committee, Ms. Wise is a member of the bar. That means she sat there for how many days we sit there? 2 days?
Yes.
And it's been a lot of money. Maybe her parents, maybe she's lucky if they paid. She is a lawyer. She is going to ask you questions after he gets finished to help we either say rehabilitate or clarify. Let her do her job, please. Just let her
Okay,
do
Your
her
Honor.
job. The first answer when he asks you a question needs to be yes or no. She's taking
Your Honor.
copious notes. Let her do her job. All right, counsel, go ahead.
Okay, may I continue?
Oh, and go ahead, Ms. Wise, if there's something else you want to say.
I wasn't sure if you meant me. I was just going to say, Jason, I agree with the judge. Just stick to the short yes or no, and then I will ask you later.
Okay.
I agree
have
with
a
the judge as
significant amount
well.
of trauma associated with my last encounter with.
Stop,
Mr.
Mr. Committee. Stop. I'm not Judge Houston. Go ahead, sir.
I'm tendering, Your Honor, as
Hi, Model 10.
evidence.
Hello.
10 and 11. That would be the letter that was delivered and the video of him delivering the letter.
So 10's already been admitted, but same objection to 11.
Okay.
All right.
Mr.
I'll let
Committee,
11 in just for the sake of, and give it what little weight it should get.
but
No,
Mr.
Judge,
Committee, you
it's
knew when you
clear.
delivered that letter on January 2nd that you were prohibited from doing that, right?
Sure, yes.
Okay. I'm going to go to a Facebook posting, what we have put up here as Exhibit 12, and ask if you can identify this as something that you posted on Facebook, Mr. Committee.
Right now, I just see a blue screen, John.
Oh, I'm sorry. You know, I'm sharing the wrong screen. How do I change that again?
You
Here
have
we
to
go.
end it
Okay.
and then,
Okay, and then
Share again.
share. I apologize.
That's okay.
Okay. Mr. Committee, can you see that?
Yes, I can.
Is this a Facebook posting that you posted?
Yes, it is.
Okay. And you mentioned Samantha, thought I was mad at
Close
you,
your
Hala.
eyes. There's bad
If
words.
you don't know, come on and I'll show you why Samantha is so fucked up in the head, LOL.
Your Honor, for efficiency, I'm trying to stop, but we got to
I'm
have
sorry.
these tendered first.
I apologize. I tender Exhibit 12.
I would just like when it was posted to be clarified.
Mr. Committee, can you tell the court when you posted that?
It's really not hard. You've been doing this for 30 years? For real?
I can't see on the screen when you posted it.
It doesn't
No,
show.
I don't know. I don't know when I posted that, no.
Okay. So you could have posted this after the January 23rd hearing, correct?
I can't answer that one way or another.
Okay.
Without the date in front of me, I can't tell you.
Your Honor, I tender Exhibit 12.
Same objection and the fact that, we don't have the date. It's not really. They haven't laid that foundation.
Is it accepted, admitted?
What, do you remember the year, Mr. Committee, anything, or you just saying you don't remember doing it at all?
I don't remember if it was 2021 or 2022, Your Honor. I can't tell you.
All
Mr.
right, so go ahead.
Could it have been January 18th, Mr. Committee?
Without a date on there, Mr. Tonic, I can't tell you that. Your Honor, may I ask for 3 minutes to use the restroom?
Okay, sure.
No, that's
Okay.
not allowed. No, I'm kidding.
Well, okay, so I want to admit that one since you can't do that, but yeah, anybody else need a break? Take a break.
I'm gonna grab some water then.
Sure,
So we're going to come back in like 5 minutes?
sure.
This is going to be the longest 5 minutes
I
of my
pause
Viber's life. You shut up. You just shut up. Just shut your mouth, sir. We've had enough. I can't handle you anymore. Oh, no. This lawyer just got my blood pressure through the roof, and now I have to go into OJ. Oh, no. I'm going to have to do something before OJ. Shirley Temple, Shirley Temple, Shirley Temple, Shirley Temple. I'm so sorry about the technical issues, guys. I'm working on it. Well, you know, every mess up gets me a little bit closer to not messing up, right? Right? So, thanks for coming out. I really appreciate it. I can't wait to get to the rest of this hearing. I wish I could just press play. We could just watch the whole thing. I really do. But no, this is for tomorrow. This is our Tuesday morning. Oh, it's going to be a fun morning tomorrow. Give me just a second to set up OJ, and I'll be right back, guys. I hope the rest of you have a great day, and I'll see you again real soon. All right? Bye, guys.